Thank you for joining us. Before we start the program, a couple quick housekeeping items. First, the audience has joined this webinar in listen-only mode. You can ask your questions via the questions component of the webinar dashboard, and we'll address as many as we can at the end of today's program. Second, the handouts, including the bios, are available in the handout section of the webinar dashboard. Third, this program is being recorded. Everyone will receive a link to the webinar replay and the handouts once they're available.
Hello, everyone, and welcome to the So You Want to Be a Bankruptcy Judge, Preparing for the Role and Application Process. This program is brought to you today by the ABA Judicial Division's National Conference of Federal Trial Judges and the Young Lawyers Division. I am Katrina Castillo, and I will be serving as today's moderator. Joining us today, we have the Honorable Frank J. Bailey from the District of Massachusetts. We have the Honorable Elizabeth Snow Stong, Eastern District of Massachusetts, and the Honorable C. Ray Mullins, Northern District of Georgia, retired. So to start off, we're going to talk about three pathways to the bench. There are many pathways to the bench, but we're going to go ahead and have the judges tell us their story. So Judge Mullins, why don't you start us off?
Okay, well, I'll give you the Cliff Note version for sake of time. So, when I graduated law school long ago, there weren't very many firms dedicated that had real vibrant bankruptcy firms in a manner most people understand it now, especially in a big Chapter 11. So I was in a small firm in Ohio doing just civil litigation, had a case that I tried, got a judgment against a company, small company, and just start chasing them to get the money from the judgment. And just when I thought I had found a bank account and got ready to put a freeze on it, got a call from a lawyer said, if you do anything else, you're going to be in violation of the bankruptcy code or the automatic stay. I had no earthly idea what he was talking about. So I just ran to the library, got Collier's, looked up automatic stay, realized I couldn't do anything. So I was so frustrated, I told the managing partner I'd like to find a seminar to learn this new animal called bankruptcy. And I went out of all places to Caesar's Palace and met, Ken Klee and that crowd, the early, authors of the 78 Code. It was a wonderful Patrick Murphy, et cetera. But anyway, so once I did that, I was about 5 years into practicing. And I just kind of fell for it. I just thought it was a very creative practice. It had elements of business, had litigation, negotiation, mediation, all wrapped up into one. And so at that point, I realized I wanted to do large Chapter 11 work. I was practicing in Ohio. I knew I had to go to a larger firm. So I had a classmate who was from Atlanta. She moved back ahead of, and it said I checked out their bankruptcy practice and just went down in 87 and just planted a flag there and practiced for about 13 years. And fortunately, the bankruptcy group had one client that was a large savings loan that had single asset real estate cases all over the country. I think I ended up litigating cases in about 15 different states, and that really was an eye-opener. And just every case was different. I had an opportunity to do a lot of creative things. And so going around to various courts, the more I did it and the more I realized how portable it was, following a code-based practice and so forth. Start planting the seed that this wouldn't be a bad kind of crown capping to get on a bankruptcy bench. And so after about 13 years or so, an opening that came about in 99, and I just tossed my hat in. I was very happy what I was doing, but I thought, this is an opportunity to see if it was the time. And on my first application, I was fortunate enough to get the position, and I went on the bench in February 29, 2000, and just had a wonderful, wonderful time. And so maybe some of the questions down the line here talk a little bit more about it, but I don't want to hog up too much time. But that's kind of the Cliff Note version.
Thank you, Judge Mullins. Judge Stong, why don't you tell us a little bit about your path to the bench?
Yeah, thank you so much, Katrina. And it's really kind of the other end of the spectrum because in many ways, I think I was the least likely candidate for the bankruptcy bench. I never, ever practiced bankruptcy. I was for 20 years, I was a district court law clerk after law school in the District of Massachusetts, then moved to New York, figuring I'd practice here for 2 or 3 years and went back to the firm I'd been a summer associate at, figuring 2 or 3 years of New York would be enough. After all, I am from San Francisco, and, not many people move from San Francisco to New York, but I loved it. I absolutely loved it. And after 3 years at Cravath, I moved to Wilkie Farr. I spent 17 years there as a litigator, never doing bankruptcy, and not really, frankly, thinking that much as I love the federal courts, there would ever be a path to the bench for someone like me. I'm not especially involved in political things, and while, of course, the Article 3 bench is a merit-selected bench, there is a component of the political process. I was active, and we'll talk more about some of these things later in the program, I think, in bar groups and in things that were important to me, helping courts be as good as they could be, state and federal, along with my litigation practice. And it was something my firm, at the very least didn't discourage and to a great extent encouraged, and that was a good thing too. And I was at a day-long meeting at the New York City Bar, representing the Judiciary Committee of the New York City Bar, which reviewed and didn't appoint, but screened for qualified or not qualified candidates for all the different judicial positions in New York City, of which there are quite a few. And kind of slipped into the back of the room of the federal panel and heard a very interesting presentation from a then fairly newly appointed bankruptcy judge. This goes back to, maybe 2001, 2002. And he said, look, if you're interested in a court that has very interesting financial issues to decide, and now my own version of this would be, and a court that has the opportunity to help ordinary people, to help families and individuals get back on their feet and save their homes, and has no criminal jurisdiction, but has within a specialized area, a very broad jurisdiction to handle all kinds of problems, because the company in trouble has all kinds of problems, and frankly, families in trouble the same. You might think about the bankruptcy court, and I sort of filed it away. I didn't really know what it meant, but I was intrigued, and having never thought there would be any way I could be a judge, having a kind of a mix of a complex Wall Streety kind of practice and a good amount of pro bono work representing people who couldn't afford lawyers, I thought, in a way, what I've done has absolutely nothing to do with bankruptcy, but it's everything to do with the kind of participants in the bankruptcy process, debtors and creditors. And so a year or so later, when there was an announcement of an opening, and they are infrequent because, frankly, people tend to, once they get these jobs, they tend to stay in them for a very long time. I thought, what the heck? I got the questionnaire, the application form. Again, we'll talk a little more about the nuts and bolts later. And I realized that even though I'd never done bankruptcy, I had some things to say about what I'd done in my career concerning access to justice and equal justice under law, and things like helping courts have pro bono programs, doing pro bono work, working on opportunities for diverse lawyers and diverse law students in the profession, that all these kinds of things, I did them because they were important to me, but they also tended to help me make a case for why I might be a reasonable candidate for the bench in a court that I'd never practiced in. So I guess at this point, it's sort of the one thing led to another. At that point, I'd been in practice 20 years, and actually my mom had fairly recently passed away, and I was thinking some kind of big thoughts, and I loved my firm. I had great partners and great colleagues, but it was also clear to me that, maybe you can do more than one thing in your career, and that a time to think about it is not necessarily when you aren't happy, but maybe when you are happy with what you're doing and how things are going. And so I dropped off the application, 7 paper copies with a writing sample saved on a thing called a floppy disk, figuring, frankly, I'd never hear anything more about it, and was pleasantly surprised to get an interview and even more surprised to get the call that I had been designated for my seat. So I guess that's some of the nuts and bolts of it. And my particular pathway, I think the overarching thing that it shows, at least to me, is that if you do the things you care a lot about and you remember to do them sort of no matter how busy you are with your client work, then you may well find that if the bench is for you, you've got a good story to tell when 20 or 25 years down the road from graduation, you think, well, maybe I will put my name in. So that was that was my path. And I'm here in the Eastern District of New York. I sit in Brooklyn. Judge Bailey.
Oh boy.
Hi, Judge Bailey. You may be on mute.
Now I have it. Let me start again. This is Frank Bailey. I apologize. I had it on mute. So I'm Frank Bailey. I serve in the District of Massachusetts. I have been on the bench since early 2009, and I sort of split the difference between Judges Stong and Mullins. When I graduated from law school, I was a law clerk at our state Supreme Court, and I really fell in love with the notion of judging, and thought, if the day comes, I would love to do this, but now I have a career ahead of me, so let's keep it in mind. So I started at my law firm as a litigator. It was a kind of a big-ish but regional firm, and in the litigation department, the first thing they gave me to do was to work on writing a cross-examination in an ICC case, Interstate Commerce Commission case, and that was my job for 6 months, to write one cross-examination. So then when somebody came in and said, go see this guy about a bankruptcy case, I thought, well, it's got to be better than this. So I was assigned to a bankruptcy case, and I figured out that everything that happens in a bankruptcy case happens in court. There's usually a need to go get approval of things, and so all of a sudden I was, questioning witnesses on the stand. I was taking going to 341 meetings, which is like a deposition, and asking questions or defending our clients at them, and it was a much more fulfilling practice for me, and all of my friends in litigation were not getting a chance, to develop a lot of those skills. So I thought it was, I really sort of fell in love with it very quickly. I did bankruptcy for a few years, and left that firm, joined about a 60-person firm where I was the bankruptcy guy. But right about that time, most of the commercial bankruptcies, the bigger cases, were all going to New York and Delaware. So I stopped doing bankruptcy for a long time, probably 15 years. I did whatever came in, but that wasn't all that much. And I was, again, now a full-time litigator, and I had gained a lot of skills because of my bankruptcy work. So then along came this ad from the First Circuit saying we're looking to hire a bankruptcy judge, and I read the ad, and I still loved the bankruptcy practice and the bankruptcy bar, and it said that litigators are straight out litigators are encouraged to apply. It even said business lawyers are encouraged to apply. It was a very broad description, and I thought, well, this might be my chance, and it's the federal court. How great is that? I'll have lots of resources, and I never thought again, this is the theme by all of us. I applied for it, and after I went through the merit selection panel and then on to the First Circuit, I had an interview. I went home and said to my wife, you know what, honey, I'm afraid I might get this. So we better be ready for me to say yes. And she said, absolutely, you want to do this, you say yes. So that was how I ended up on the bench, and I knew zero consumer bankruptcy, and most of our docket here in District of Massachusetts is consumer.
I have to add a footnote to what Judge Bailey just said, because it's very funny. The application was due in November, and then on December 17th, I'll never forget, I was summoned, told, not asked, to come to the interview with the merit selection panel here in the EDNY, which was a group of judges, district and circuit. And I left that interview and took out we can't really call them cell phones, they were so big, it was as big as a shoe. This was 2002. I called a friend and said, oh my gosh, what an incredible experience. I've learned so much about myself, so much about the law, so much about our system that I hadn't really seen from this perspective. It's not going to happen, and that's okay. But, oh my gosh. So I walked out with the opposite reaction of Judge Bailey. So don't worry if you walk out of the interview, whether you feel very, very good or like, that was incredible and it's not going to happen. That's telling you more about you maybe than it's telling you about how you stand in the process. Sorry for the footnote.
Well, thank you, judges. I appreciate that. So we're going to go ahead and go to our next topic, which is what skills do bankruptcy lawyers need in order to be successful? So Judge Song, what do you think is the most important skill that a bankruptcy attorney needs to be successful, either on their pathway to the bench or just practicing in front of you in general?
It's easy to think about it because I was on the bench until about 10 minutes before we started. And as you see from the notes and the slides, trial and litigation skills are probably top of the list, but I have a slightly different view of those than you might think. If, for example, in your law school trial advocacy class, between the 20 years as a litigator and now 15 as a judge, I think of trial and litigation skills as comfortable on your feet in a courtroom, able to have a conversation with a colleague, with the judge, and always thinking about your role as at least in part being a problem solver. So problem solver skills that you can display in the course of trial and litigation, case conferencing. We do an enormous amount of that in the bankruptcy process, arguing motions, but not arguing in the sense of, being disputatious, I'm right and my adversary is not only wrong but clueless, but looking for ways, as the bankruptcy process does so relentlessly, that maybe everybody is a little bit better off if the plan is confirmed, if the motion is resolved. So trial and litigation skills and the ability to deploy those in a problem-solving way, I think, is the signal skill of a good bankruptcy lawyer. And I've had billion-dollar cases, and I have many, many, many consumer cases, and across the spectrum, I would say that's the most important skill.
Thank you, Judge Song. Judge Bailey, why don't you tell us what you see in your courtroom as the most important skill for a bankruptcy attorney have when they come in front of you?
Well, bankruptcy is a curious specialty because it's both trial presentation, litigation skills Judge Stong just talked about, and those things are really important to the process. You need to know how to ask a question in court, but it also involves significant both advocacy in writing, like any litigation position, and it also involves what I'll call drafting, not so much writing, but drafting of documentation that look a lot more like what business lawyers do, corporate lawyers do, because the bankruptcy process involves adjudication in court, but ultimately it involves drafting plans and disclosure statements and other kinds of transactional type documents. And in a litigation practice, you would rarely, if ever, be called upon, to draft transaction documents, maybe a settlement agreement or releases and things like that. But that was about all I saw. It's way beyond that in bankruptcy. A disclosure statement and a plan in a Chapter 11, Business 11 case, or even an individual 11 case looks an awful lot like a prospectus. And so what that's a whole other kind of skill. And then, of course, the writing skills, advocacy. Although we have an awful lot of hearings, generally bankruptcy judges have read the things you've submitted to them, and by the time we get into the court, we're most of the way toward persuaded if your writings, if your submissions are good. And so you get to practice all of those skills. They're both vitally important.
Well, thank you, Judge Bailey. And Judge Mullins, when you were on the bench, what did you see as one of the most important skills that a bankruptcy attorney should have?
I think there are a couple. I think one, I think that stands out is the kind of bromide you get from real estate value is the 3 tips: location, location, location. Well, I think for a bankruptcy judge, effective one is preparation, preparation, preparation. Know all aspects, especially one of the things about bankruptcy, some of the old bankruptcy lawyers would call it the last of the generalists, that we were the last of the generalists because you had to take this code and know it. But every case you'd get in, especially on the business side of things, whether it's a retail or whether it's a manufacturer or an airline, I mean, you have to learn the business and then have the code applied to it and resolve the problem. So you really have to prepare for it so that you can explain the business of your client to the court and understand from the beginning where you want it to end. Sometimes people, especially in the business side, they'll come into bankruptcy, but they don't think about how they get out. And so you've almost got to be thinking preparation from filing it, and then what's the exit plan. Frank talked about the disclosure statement and plan, but you almost have to be thinking about how you exit before you get in, else you could find yourself wandering, and that's not a good thing to have. I think a couple other things. I think you have to prioritize your arguments. You got to lead with your strongest argument. I see too many lawyers that would have, like, I've got 14 points, and then they want to run out all 14 points. And what could happen is your advocate is smart, and they could take one of your lesser points, twist the argument, or throw a red herring in there, and next thing you know, your strongest argument kind of gets laid by the wayside. You find yourself trying to explain minor points that really aren't the winners. And so I think you got to take all your points, and then by the time you get to court, synthesize it, because as Frank said, we have read the papers and we have experience, so we kind of have an idea of how this should go, and we still have an open mind, but we have a general idea how it goes. And if you get in and you just throw the kitchen sink and cause confusion, that ends up causing long hearings, resets, additional briefing. And in a bankruptcy case, especially if you represent a debtor, you don't want to do that. That's why some people call it a melting ice cube, because the longer the debtor is in, hemorrhaging cash, etc., it's not good for any of the participants. So you've got to stay focused, keep a priority, get your arguments straight, and guide the process. And then the other thing I'll say lastly is, since you're in court so much, I find one of the things that the better lawyers, I would call active listening. They're listening to everything. They're listening to every word I would say, or Frank would say, or Elizabeth, because it gives you an indication of where the judge's mindset is. They listen to all the arguments. They listen to the witness carefully. Sometimes people get in and are so busy talking to their client or talking to their associate or their partner, they miss something. You got to be an active listener, I think, to be an effective bankruptcy judge also. And then on top of that, because things shift and you have parties in interest, it's not just A versus P, plaintiff versus defendant. You could have a bank group, you could have a creditors committee, you could have a bank group in, and so you've got to be able to think on your feet, because a lot of times the ground will shift under you during a hearing. So you've got to be able to keep your eye on what you're trying to accomplish and be able to think on your feet and be able to kind of change gears. And so I think those are some of the things that I noticed about the better bankruptcy judges that I was honored to have appear before me.
Well, thank you, Judge Mullins. And sticking with you, why don't you give us a very quick general overview of what a week was like in your court or your chambers when you were on the bench?
Well, much like Frank, I did almost in practice almost exclusively Chapter 11 work. A lot was creditor side, and then I spent a couple of years doing debtor side work also. And so, but then when I came to the bench, we have one of the larger Northern District of Georgia in Atlanta. I have one of the largest Chapter 13 caseloads in the country. It usually runs one or two in the country in Chapter 13 cases. So a lot of my weeks were spent in the consumer arena, but this is still a fairly large commercial center, so we have some 11s tossed in, and so you'd have to handle both, obviously, and so the consumer calendar is much easier to schedule because they are coming in all the time, whether it's Chapter 7 or if you have a Chapter 13 case. Most judges set certain days of the week, and they know like for me on Tuesday, I knew it was going to be my Chapter 13 calendar. On Thursday, I knew it was going to be miscellaneous 7-11 motions that were mainly 20, 30 minutes of argument and then decisions. And underneath both of those instances, I would rule from the bench almost 99.9% of the time based on the arguments and papers if they were submitted. Then every now and then you have a large Chapter 11 tossed in, and you just deal with, first day motions, whether it's making payroll or, trying to keep utilities going without increasing the deposit, so forth. So that could be a variety of issues. And so those, you don't know when they come in, but usually they come in with emergencies and you're setting a hearing really fast. You don't really have an opportunity to review much because there's not much in the way of background file. It's just the cause for the emergency. And so you're kind of catching up on the fly, but those are very tricky in that, usually it's all debtor driven because they're so fast. A lot of times creditors don't even have an opportunity to get to those first hearings. So you have to kind of be a bailiwick. You have to be kind of the person that kind of slows it down, make sure things get off the ground and emergencies are handled, but you don't want to let the horse out of the barn and give too much away, and before creditors or creditors committee or U.S. trustee gets an understanding of the case. And so for my 18 years, that was kind of a typical week.
Well, thank you, Judge Mullins. Judge Bailey, what's a typical week like in your court?
I'm going to focus on the consumer part of what we do, but we certainly here in Massachusetts also have Chapter 11 business cases, sometimes fairly substantial cases involving complicated lending arrangements and sometimes fairly complicated assets. Like we tend to have a lot of intellectual property assets here in our cases, and so how to sell assets of that sort. But I want to focus on consumer. One of the great attractions of the job is that one day I could be doing a sale of some app, some intellectual properties, maybe a healthcare, a pharmaceutical business or something like that. But the next day I could have 25 or 30 Chapter 7 and Chapter 13 individual consumers, who are either trying to restructure their debts and pay it over time in a Chapter 13 and hold on to their home, or in the Chapter 7 list, where people are either don't have a home or have decided they can't afford the home or something like that, and you're helping them wind up all of their credit card debt. And I wrote on this slide, how the judge can help a family from losing its home. One of the first weeks that I was here, I had a family in, and the patriarch was here, and they had had a very long and difficult run with their mortgage lender. They had been in the court here before I got here for probably 2 years, kept failing at a Chapter 13, had converted to a Chapter 7, and were really going at it hammer and tong through their lawyers, with the mortgage company, and I really learned something from that case because it was a motion for relief from stay. The bank wanted to go foreclose, and I said to this patriarch of the family that I felt strongly that I had to allow this motion for relief from stay, that I didn't think that it made sense for them to keep finding a few dollars here, a few dollars there, that it was much better for them, that they really couldn't afford the home anymore. And I thought, this guy is going to say, who are you to tell me that? But he actually looked at me and shook his head, and I realized, I'm impartial. He knows that. I'm probably telling him the right. He knows that finally there's somebody other than his lawyer who he's paying, and lawyers don't often want to tell their clients bad news, that he could accept this because it was coming from me. And I realized the power of the office when I went through that hearing. So the fact that we, can deal with, larger commercial cases one day and a consumer bankruptcy session the next day, to me, adds an awful lot of great fabric contour to the job, and I'm positive my colleagues would agree with that.
Absolutely.
Well, thank you, Judge Bailey. Judge Dong, can you tell us a little bit about what a typical week might be like for you?
A typical week is quite a concept. I've been doing this just, I guess, 14 and a half years. I was reappointed last fall, and I don't think I've had 2 weeks that are the same. I want to focus a little bit on kind of the management side of what we do. On the one hand, you won't really be billing your time, although very soon after I went on the bench, the AO, or Administrative Office of the United States Courts, which is part of the third branch, did a time management study, and to my great surprise, for 6 weeks, I was required again to record my time and what cases I was working on. But your management role changes as a judge. You're running chambers. You're responsible for hiring law clerks. You are managing your caseload, though you will have indispensable assistance in that from your courtroom deputy, who is dedicated to chambers and to your cases in every sense of the word. You'll be managing case by case in the courtroom and in chambers, so that I always like to think, this happened as recently as this morning, when a Chapter 11 comes in on case management, what are we doing today to move this case forward? So you're managing like that. Courts are enterprises. We have 3 judges here in Brooklyn, 3 in Central Islip. We have about 100 clerk's offices employees. We have interns. We have visitors. We have more moving parts than you would think. We have, of course, a relationship with the district court. We have crossover roles. We do naturalizations. In New York, we can do weddings. But there's a lot of management that goes along with the job within chambers in the courtroom, and also a lot of opportunity to use this incredible treasure that is the federal court system to make things better, to make things work better. We adopted a loss mitigation program to help lenders and homeowners who were in default on their mortgage to exchange information and see if they could work out a modified mortgage. And it has been helpful in an astonishing number of cases. I say astonishing because most of these cases come to the bankruptcy process after the mortgage has been in default and probably after a state court case has gone badly and maybe even a foreclosure sale has been scheduled. You'd think, what in the world could you accomplish at that point? Well, it's the power and therefore the opportunity of the federal court to, in loss mitigation, have a management tool available to the parties to say, we're going to take a couple months and focus on whether or not there's a result that makes even more sense in the form of a modified mortgage for the parties. That came from a court initiative. We adopted it pursuant to a general administrative order, similar to a local rule. Diversity, of course, always something as a public entity, always something we're mindful of. We need to be responsive to and reflect in every way we can the diversity of the populations and the communities we serve and the country that we serve. And so that's something we think about in outreach. That's something we think about as we have courts in the community and bring the community into the court. It's something we think about, of course, in our hiring, and it's something we think about even in programs like this, where we want to be sure that the next generation of bankruptcy judges is as diverse as the participants on this call, including your judicial participants. So those are parts of a week in the life of a U.S. bankruptcy judge too. Another piece of that is something we do for each other. It doesn't get a lot of attention. It probably shouldn't, but it's worth people knowing that we, from time to time, serve as mediators for our colleagues in their cases. This is because in a bankruptcy situation, whether it's a Chapter 7 individual debtor or an enormous Chapter 11, multi-company restructuring, this is another kind of quiet tool that judges have. Some judges come to the bench with experience in serving in that role and like the opportunity from time to time to continue in the role of a mediator. It's much harder in a way than being a judge because you can't make anybody do anything. And as a judge, at the end of the hearing, you can rule. But that's a little piece of the management process as well, something that we do for each other as a court. But a typical week, I don't think I've had a typical week yet.
Well, that's a fair assessment, Judge Stong. And Judge Stong, sticking with you, why don't you tell us a little bit about the help you might get from either your law clerks or your interns that you have in your chambers?
Absolutely. The standard protocol years ago, back when I was clerking for Judge Mazzoni in the district court in Massachusetts, was that a district judge had 3 chamber staff, a secretary, judicial assistant, and 2 law clerks. Bankruptcy judge had 2, typically a secretary, judicial assistant, and 1 law clerk. Over the years, that has migrated and I think at this point, most chambers, so that a bankruptcy judge has 2 full-time chamber staff at least. I have 3. We have a heavy caseload, so we have some additional personnel. And pretty much because, unlike back when I clerked in the mid-1980s, people do their own typing, for example. Law clerk positions are typically, I think, at least 2, sometimes more in very busy districts in each bankruptcy chambers. A lot of bankruptcy judges have career clerks. This is someone who comes and stays from year to year to year, provides some continuity. Most bankruptcy judges also hire 1 or more term clerks a year. These are anywhere from straight out of law school to many years in practice. These are, by the way, absolutely wonderful jobs and interesting and engaging and the best kind of public service and one of the best parts of being a bankruptcy judge. So probably first and foremost, we have our law clerks. I've already mentioned courtroom deputies and how essential they are to the court running smoothly. My own view is that, and judges differ on this, and nobody's wrong if it works for them, that, for example, when a lawyer calls chambers, the only person they should talk to is my courtroom deputy. I don't have them speak with my law clerks. They would certainly not speak to me. The reason I follow this rule is that I work so very closely with my law clerks that my view of speaking to them is like speaking to me. So courtroom deputies perform that role as well. Interns have been a tremendous part of my own experience as a judge. Typically, we have fall, spring, and summer. Fall and spring are typically a day and a half a week in connection with a law school program. These are unpaid positions, of course, or as we like to say, all of the compensation is non-taxable. It's professional satisfaction and learning, being part of Chambers family. In the summer, we have full-time interns. These are wonderful jobs, again. And most semesters and most summers, we've had, in the last many years, at least one from outside the U.S. And this has ranged from Europe to the Middle East to Africa to Asia. And that's really enriched our chambers' lives as well, because we get an exposure to a very different legal system. They, of course, do the indispensable work of chambers, but they give us another perspective on the work that we do, and having that additional perspective, I think, makes us better at it. And then, of course, they go forth, and we wind up with chambers family, spanning the globe. Maybe one of the most unique of these opportunities was 6 months last fall when a sitting judge in Korea was seconded to the United States to first to do an LLM degree at the Fordham International Law Program, and then to stay for 6 months in a training capacity. And he was a chambers intern. I was wondering about how well that would work, because frankly, you can only have one judge in the chambers. But of course, we only had one judge in the chambers, and not only was his work terrific, but we also learned an awful lot about a comparative perspective on much of what we do. So you get a lot of help as a judge. You get it from the lawyers, but you get it from your chambers team. And not to say at the end of the day it isn't on you, it is. And that's one of the most interesting part of the job, that really does begin and end with the judge. But in between, there's an awful lot of people helping you get your job done.
Well, thank you, Judge Stong. I appreciate that answer. Judge Mullins, why don't you tell us just a little bit about what kind of support you might have gotten from professional organizations, maybe the FGC or another, the other, judicial professional organizations while you were a judge?
Okay, thank you. When we all of us get first sworn in, you get your first two contacts really are the administrative office of the U.S. courts and the Federal Judicial Center. Administrative office is just what it says, administrative arm. They handle the court's budget. They handle clerk's office, clerk of court, and all the employees. They handle education for them. They handle all the benefits, so we get a contact right away about insurance and other benefits because there are certain deadlines, so we get that right away. And the second contact, so we get off on the bench, is sometimes actually before, once we're cleared by the FBI and IRS, and they give us the okay, clear. Even before we're sworn in, most of us have gotten immediate contact from the Federal Judicial Center, because the first part of the continuing year by year education for us comes through the Federal Judicial Center, who has two main goals: education for the judges, and then research for the issues that come up on a bench. So all of our first contact with the FJC is what's formally called Phase 1 and 2 training for newly appointed bankruptcy judges, but we all call it Baby Judge School. And so once we're off and running. Usually it's 2 phases, as it says. At the beginning, it's about 3.5 day program. Kind of moves around the country. It depends on where the mentor judges happen to be. And then the second one is almost always in D.C. And then from that point on, the education keeps going on. It moves then into phase of every year. Federal Judicial Center puts on bankruptcy workshops where it covers topics that the bankruptcy judges are interested in. Those are usually 2.5 day workshops. 2 cities. We try to do east and a west, and those are, like I said, 2.5 days. And so you have half the judges go to one location, half to another, and then every 5th year there's one bankruptcy workshop, and all the judges are invited to come. And so the FJC is really a part of our daily life in terms of continuing kind of legal education, so to speak. And there are also, in addition, the FJC runs focus programs. Sometimes they have very little to do with bankruptcy, but it's generalized areas that are real interesting. And for me, some of my favorite programs were actually some of the focus programs that really didn't have much touch to bankruptcy, but just were interesting and fantastic speakers and just good camaraderie. Example, there's always a Harvard Law Society program that we're invited to, and they're the judges from the District Court of Appeals also. And then, for instance, intellectual property it's always held out in Stanford in January generally, and they're judges from all the federal courts, and those are fantastic programs. And so those are the two kind of chief support organizations, and I was fortunate enough to be a mentor judge in baby judge school for about 10 years, and I was on the board of the Federal Judicial Center for 4 years, and so it really was a wonderful, wonderful experience. I got to meet almost all the new bankruptcy judges that came through in that 10-year period, and that was our way of having our education in person, and so that helped boost the camaraderie because the bankruptcy bench is fairly small compared to the district court bench, and so it was just a wonderful opportunity to get together with our friends and colleagues from around the country, and that's one of the ways that we kept in touch and shared ideas, and it was some of the things that helped me the most because we'd get in chambers and you're there with your law clerks and your courtroom deputy, and may talk to your colleagues, but you may have a way of you settling into what you do. Then you go off to a workshop and you're sitting there with 150 of your colleagues, and you get in small group sessions. Something comes up and you realize you've heard some back and forth. All of a sudden you realize, well, I've been doing it this way, but I think I'm going to try this. And so it's a constant, if you take advantage of it, it's a constant testing of what you're doing. And so by participating in this, I just felt that it helped me be a better judge because there was always opportunities to have a check on what I was doing by interacting with these very, very, very skilled, dedicated professional colleagues. That was just a wonderful experience. And then you never really are done with the AO because I'm retired now, and so you still are in contact there for your pension and thrift savings and so forth. So it's really a total ongoing from the beginning to the end, and so that's kind of the summation of it.
Well, thank you, Judge Mullins. And Judge Bailey, why don't you quickly just tell us one or two of the benefits that you see as from being a bankruptcy judge?
Well, I will. I'll just comment that my colleagues who just talked about law clerks and interns and the judge education, particularly the annual education that we get, those are two pretty much the most important. Those are a couple of the greatest benefits of the job. My relationships with these law clerks and interns who have gone on now 10 years, is ongoing. We get together if they're in the Boston area with some regularity, and a couple times a year we have gatherings where they all come back, and now they're coming back and bringing their little kids with them, and it's just great. It's a wonderful experience for me, and my relationship with my colleagues are 330 or 350 or so bankruptcy judges in America. They all face the same things every day, and I have to tell you, when you get this job, you got 330 to 350 best friends because everybody's out to help you as best they can. As far as the benefits are concerned, yeah, we do get paid for this job. It's a good salary. It's a great retirement. The term of the office is we're appointed for 14-year terms, which are renewable. The other two judges on this call are, Ray has retired now, but he was appointed for 2 terms, a second term. Judge Stong has just been appointed for a second term. So you are, the 14-year term, can quickly turn into a 28-year term if you decide you want to stay that long. I want to mention also another different kind of benefit, and that's public outreach. We do financial literacy programs for high school here right in our courtroom. So the kids come in from the high school and we have a play acting kind of a situation for them, and take questions. We do a Goldilocks program where fifth graders come in and act out the trial of Goldilocks, and the bar people from the bar come and act as coaches to these kids. And in many instances, it's their first introduction to court in a non-threatening, positive experience for them. And I just consider myself fortunate every day that I get to do things like that. So, Katrina, I suggest that we skip the next slide for a moment, come back to it, because people want to hear about the application process. So if you go to the next slide, the nuts and bolts slide, I think perhaps we should go to that.
Absolutely, Judge. I totally agree. So then, like Judge Bailey just said, we're going to skip to kind of the actual application process for becoming a judge. So Judge Mullins, in the 11th Circuit where you served as a bankruptcy judge, what was kind of the process of getting to the bench? What was the merit selection panel like?
Okay, well, the 11th Circuit, we don't have a merit selection panel like most circuits in terms, because most circuits have, and sometimes it's bankruptcy professional, other lawyers do the screening at the first instance. In 11th Circuit, it really is, the merit screening panel is really not true like in other jurisdictions. What happens is, like for instance in Georgia, since I was going for an Atlanta spot, they take the 3 chief district judges of the 3 circuits in Georgia, and then 3 of the circuit judges, so 6 of them, and they basically do the screening. So they go through all the applications and typically choose the number of people to go to the second step. So they screen them. There's interviews there, and then if you make it past that cut, the next step is you go to our circuit en banc. So all our 12, there are 12 circuit court judges, and so you walk into a room and all 12 of them are there, and that's the second interview. And it's really quick. There's a little time between the first step and the second step, but after I had my interview on banc, I think I got the call that I was chosen probably the next morning. So it happens pretty quickly. So that's the process in the 11th.
Well, thank you, Judge Mullins. Judge Strong, I know you talked a little bit about how your process to getting to the bench. But can you tell us just a tiny bit more about the formal application and the interview that you went on to be appointed to the bench?
Absolutely.
Okay.
One of the things you do learn from your 350 new best friends, and Judge Bailey is absolutely right, is it similar but different circuit to circuit? So it's interesting to know, like, boots on the ground, what is it like in your circuit and district? Here in the Second Circuit, at least I know for certain with the Eastern District and from my colleagues in the Southern District, what happens in the New York City seats is there's a big questionnaire, and it has a lot of factual questions, and it also has some essay questions. And I like to say to my seminar students, I teach the judicial externship seminar at Brooklyn Law School, when it says, what have you done in your career to promote equal justice under law, you can write not applicable, but you probably won't get the interview. There is an application. You list references, no less than 5, no more than 8. You list all of your adversaries. So all that stuff you think about, all the reasons why it's good to practice on the high road and be the professional you want to be, those are all good reasons. You'll get better results for your clients that way. But you will also, it will be a little easier when you list your adversaries for the last 5 years, which is the requirement on our application, to know that those are people who, even though they were across from the table from you, or maybe especially because they were across the table from you, we're going to have a high opinion of you. So you submit that application, and then a subset of that number of people is called for an interview. And again, here in the Second Circuit, it's one interview and it's only judges. There is not a lawyer screening committee. It's district judges from the district in which the bankruptcy judge will be sitting, and then a circuit judge, or one or more circuit judges. That's the interview. I thought mine felt like it took a couple of hours. In fact, I suspect it was between 20 and 30 minutes. It's at the courthouse. It's very pleasant. There are no bankruptcy judges in that process, and so interestingly, remember I'd never practiced bankruptcy. It's as far from a quiz on bankruptcy law as anything could be. It's really an opportunity to think and talk about what makes a good judge and why, how, and to what extent you might be such a person. And that's a lot of tangible things in terms of experience. It's a lot of intangibles. Frankly, the job is probably not for everybody, but if you like it, you won't just like it, you will love it. The written applications and the interview, and then it kind of goes dark and you don't hear anything except occasionally you get a phone call from someone saying, hey, I just got a call about you. And it might be one of your references, or again, at least here in the Second Circuit, it might be, a developed reference. Somebody asked somebody who else might know about you and have a informed opinion about what you might be like as a judge. And then the call that comes after that, in my case, and I think this is typical, is from the circuit executive. And for me, she said, can you be reached at this number? And I said, yes. And she said, are you sure? Because your life is about to change forever. And I thought, okay, the answer to that question is also yes. But it's like a lot of things. It's an application and an interview.
We're basically up against it. I want to do this. I'm going to ask my colleagues to do this because I think people really want to know. The second to last slide is, what are the top 5 things I need to do in my career to be a credible candidate, and when should I start to think about them? Judge Mullins, when should they start to think about it and give one thing that they should do?
I think you start thinking about it the minute you get sworn in as a judge, because it's... No.
When do they start thinking about becoming a credible candidate?
Oh, well, at that point, I mean, there's a number of years. I mean, I think in ours, it's like 5 years or something like that, or 7. But I think it just depends on where you are and how involved you are in your practice, and understand, the openings there of your large court, and, there's more opportunities come up, and you kind of look at it there. But I just think it's just something that's somewhere along the line. I think pretty much early on, I thought that was something that, given enough time where I had enough experience, that I wanted to approach. But and then once I got experience, and once I got going pretty well, and I had a credible record and a number of cases and stuff, I thought I had a record that would serve me in good stead, and then I thought about it then.
Judge Stong, what about you? When should they start thinking about developing these skills, and what are the 1 or 2 things you would say that they should do to get ready to be a credible candidate?
I think we are allowed a few extra minutes if we need it, so I'll try to keep this answer short. But my answer to the first part is very short indeed. The answer is now. It's never too soon. Absolutely never too soon. There were things you were excited about when you wrote that essay and got into law school, and those same things, caring about making a difference in the world, caring about fairness, caring about justice, caring about giving debtors a second chance and being sure the creditors get paid. But now, yesterday, now is the right time. As soon as this call ends, 2:00 p.m. Eastern time would be when is time. And what do I mean by that? What would be one thing to do? I guess, trying to be, again, succinct, show up. If there's a community activity that means something to you, don't wait until you're not so busy at work, because you will probably never be, staring at the walls hoping that you can think of something to do with yourself. You show up at the Bar Association. I don't care which one. It can be the ABA. Of course, this is an ABA call, and we're all, I think the people on the call have had some pretty good professional experiences there. And, part 2 of this webinar, if we do it, we could maybe do a deeper dive into that. But whether it's your local bar, your city bar, your affinity bar, specialized bar, whatever it is, show up and say yes, and volunteer when someone's needed to do something, so that you learn what it's like not only to represent your clients, but also to be part of the profession, and to make good, but also to give back. And if you do that stuff, if you extend yourself a little, if you get an idea and sort of run with it, and don't wait figuring that's what you'll do after you make partner, or after you get the brief done, or after you make your first X dollars, whatever X may be for you. No time like the present. These are habits you should be forming as soon as possible, and they will help you whether or not they lead you directly to the bench. They will help you love what you do, and people will respond to that. People will respond to that. So I would say now is the time, and show up is the path.
I would add only this thing I tell people that might be interested in being a judge of any sort is go onto the website of the circuit court and see if there is an application. In our circuit, there is one. You can even go on the First Circuit. It doesn't matter which one. Take a look at their application, even though you're 15 or 20 years from applying. Go down that list, and then you'll know, oh, these are the things they're going to ask me in 20 years. And if you come up with good experiences so that you can credibly respond to those points in that application, even if you never become a judge, you will have enhanced your career, because all they want to know is that you're an ethical and accomplished lawyer and a person who cares about your community, and that's what they want. That's what they want you to be. You know, this job, it isn't. The challenges really will never be, although they're healthy intellectual challenges. They're mostly not going to be the intellectual challenges. It's how to get through a 5-hour Chapter 13 session without losing your cool. Your demeanor on the bench. These are things that they're mostly want to know that you're going to be able to do. And so when you see that application, you're going to see questions that are intended to elicit answers from which they can make that determination. So go get that application and put it in your drawer and pull it out every year and say, is there anything else I accomplished this year that I can put on the application?
Well,
Katrina?
thank you, judges. Thank you, judges. I appreciate all of your guys' time today. And we have that is our time that we have today. I want to thank everybody for joining our call today, and thank Judges Bailey, Stong, and Mullins for joining us today. You guys have been extremely helpful, I think, in giving our listeners some guidance to getting to the bench, even if bankruptcy may not be their, first thought in how they'll get to the bench. So again, thank you for sharing your experience and insights with us. So for those of us from the Judicial Division and the Young Lawyers Division, thank you for listening.
All right. Are the judges still on?
I'm here. I'm here.
Okay. Tracy, are we disconnected?